Hi everyone, my name is Roxana Soika. I'm a family lawyer at Soika Law Professional Corporation, and this is Chelsea Murphy.
Hi, everybody.
She is an articling student who has focused much of her most recent research on the changes to the legislation when it comes to the Divorce Act and how it applies to custody and access. So we will see from today's video that a lot of the terminology will be changing when it comes to parenting and claims for custody and access. And I will let Chelsea talk more about that because she's the expert. But before we get into that, I just want to clarify two things regarding the Divorce Act, which will be changing, and the Children's Law Reform Act, which is also something that parties can use to bring a claim for with regard to children to the court. So the Children's Law Reform Act is basically provincial legislation, which deals with couples that are not married or couples that are married but are bringing their claim to a provincial court, the Ontario Court of Justice, for example. The Divorce Act deals only with married couples, and common law spouses cannot bring a claim according to the Divorce Act, but they can according to the CLRA. And couples that are married can basically choose to go under the Divorce Act or under the CLRA, depending on other issues in their cases. So it's very important to understand the distinction between the Divorce Act and the CLRA. So Chelsea, can you tell us what do we need to know right now about the amendments to the Divorce Act?
So the amendments are going to come into effect on March 1st, 2021, and the goal of them is mainly to meet the criticisms that a lot of the legal profession has applied to the Divorce Act since it hasn't been amended in almost 20 years, which has led to it not really being responsive to modern day Canadian families. So the biggest change, I would say, is the fact that custody and access, which are the most common terms in a family law's day-to-day work, will no longer be in effect. When it comes to the Divorce Act, we'll be focusing on decision-making responsibility, parenting time, and contact instead.
Yes. So what I like to say is that the fight for custody is over because we have a lot of cases and a lot of parents that are focused on that particular term, which is custody, right? But it's not really over. I mean, the CLRA still has the terminology, right? But I think we're all trying to move away from using those terms and just creating what's called parenting plans and putting procedures in place for how to make decisions and how to have visitations with parents. And we have been doing that so far. So, for example, when we draft separation agreements and do mediation, we draft parenting plans. And I found that quite effective, and most clients really prefer that everything is spelled out clearly and they can deal with a lot of different issues instead of going to court and seeking custody and access. So I have custody, that means I have decision making, and period. Nothing else can change that, right? So I think it's a really good way to address the reality of parenting and to just stop that fight and that focus on that term.
It's definitely a shift towards more of a collaborative approach to family law rather than fighting over custody, access, and everything. The amendments are really encouraging parties to work together in the best interest of the child to reach an agreement with parenting.
Yes. So the CLRA was already dealing with some of these things, the Children's Law Reform Act. So, for example, in making custody orders, the court was very focused on what is the best interest of the child and defining that in the CLRA. But the Divorce Act was not, right?
Yes.
So can you tell us more exactly what the Divorce Act is looking at right now and how you think that's going to play out in the future for parties in family law cases?
Yeah, so like you mentioned, the CLRA used to have a list of, well, it does have a list of factors to consider when making decisions about the best interest of the child. The Divorce Act required courts to make decisions that were in the best interest, but they never defined what that meant. They never gave factors of what to consider. So the amendments that are coming to effect in March are outlining factors that judges have to consider when making these decisions for the child. One of the most notable changes will be that the court has to consider the presence of family violence and also the cultural and religious upbringings of the child, including their Indigenous heritage.
That's really interesting. I think so far we deal with a lot of domestic assault cases, and if the domestic assault occurs between just the spouses, my experience has been that it does not impact too much on the each party's time and claim for parenting the children. So what you're saying is what we have to see as well how this will be interpreted. But what you're saying is that the presence of domestic violence just between the spouses might impact on a court's order on custody and access, or the new terminology.
Yes.
So we have to see how those things will play out, but we have already started to take into account the new legislation, and lawyers are starting to draft agreements that are more comprehensive and taking that into account and showing their clients the benefits of that. So I definitely look forward to seeing the case law, so the case law being how the courts interpret the legislation, and it will be a very interesting year for 2021 in family law.
I agree.
Thank you so much, Chelsea, for your research, and have a great day, everyone, and happy holidays.
Happy holidays, everybody.